Good morning, Aaron Lindstrom on behalf of the state appellants. I hope to reserve 2 minutes of rebuttal. Mr. Chief Justice.
You can hold.
Yes, I hope. Mr. Chief Justice, and may it please the court. Mage's breach of contract claim here can be understood in one of two ways. They're either challenging the substance of the rate of compensation, or they're challenging the process for arriving at the rate setting decision. And in both instances, there's no recourse in the Court of Claims. If they're challenging what the rate of compensation itself is, that is an issue that's entrusted by the Constitution to the Michigan Civil Service Commission. It gets to make that decision, and the mechanism the Constitution provides to review that decision is by legislative veto. So the Constitution provides that a 2/3 veto by both houses can overturn a rate of compensation. So that's entrusted to the Civil Service Commission and the political branches. With respect to the challenge to the process of how they arrive at that, that's governed by the Civil Service Commission rules. And the rules here are very specific about what the entity we're talking about can do. A limited recognition organization has, as its name suggests, a very limited authority under the civil service rules. And those 4 things that it's allowed to do under what the rules are laid out in our application there on page 12 of the Roman numerals at the beginning. And there's 4 things they can do. They can express the interests of their members. They can represent members in a civil service grievance hearing or technical appeal. It's not an issue. They have a right to be heard by the employer, including the Employment Relations Board, which is another hat that the Coordinated Compensation Panel wears. And then they have a right to union leave. They don't have a right to contract. The civil service rules provide only a limited right to contract, even for exclusive representatives. They can enter into collective bargaining agreements, but agreements are only binding if they're approved by the Civil Service Commission. So the only agreements that are binding under the civil service rules are those made by exclusive representatives and approved by the commission, and that's not the case here.
Counsel, the Mage has argued, in addition to the loss of the arguable loss of the 3% that the parties had agreed to advocate jointly, that there is an associational injury. If even assuming that nobody other than the Civil Service Commission and its plenary exclusive power to adjust rates of compensation, that the 3% claim is within the bounds of that plenary Civil Service Commission. What about these ancillary injuries that are asserted that the failure to advocate as promised created an associational injury to the reputation of Mage among its members? Why is that outside? Why isn't that within the scope of the Court of Claims jurisdiction?
I would say it's not within the scope of the Court of Claims jurisdiction because that's something to be resolved by the executive agency under its own rules. And if somebody wants to go through that process, they did here. And so you can bring an unfair labor practice challenge. You can also raise it, as they did here, with the Coordinated Compensation Panel itself and say you should make this recommendation because they didn't stand by what they said. So you can make those arguments.
There may be a causation problem. They actually got the benefit of the bargain, even though the state employer opposed the increase. The CCP recommended to the commission that it be raised 3%. The commission rejected it. So there may be a causation problem ultimately, but the question I have sort of is ancillary to that. Before somebody determines that they can't even make the claim for damages, why isn't that a damage claim that is removed from the civil services exclusive plenary jurisdiction?
It's not removed because that reputational injury exists to an entity that exists by virtue of the civil service rules, and it has authority to meet and confer. So all of its reputation is within the Civil Service Commission framework, and I would think they might argue that the reputational injury is going to be affected by the...
Suppose the state employer slandered Mage, said this is the worst employee representative organization known to man, and only a fool would belong to it. Suppose it was a slander claim. It's a reputational injury. Would that also be within the exclusive jurisdiction of the CSC?
There's a part of it that would make me think yes, because this is an entity that only exists under the rules. But to the extent they have a separate existence, then they might be able to bring that outside, because that's not an administrative part of the decision. We're not saying that there are no injuries that they could claim. We're saying that the injury that they're talking about in this case has to do with the process, and it's been remedied through the available processes. They've remedied it by, for example, telling the Civil Service Commission that the Office of State Employer is not following through, and so there's a reputational kind of penalty that's imposed on the other side when the agreement doesn't go through. So it's kind of like a political process in some ways, where it's something that gets resolved internally within it, where it'll affect these repeat players in future years as they decide on whether or not they're going to reach consensus agreements. So it's already resolved within that process. And I also don't think that that they're making that much of an argument of that. They're arguing about fringe benefits, which is another type of compensation. But to follow up on one point with respect to the procedural elements of their claim, which is to say that they had the opportunity to raise these claims with the ultimate decision maker and with the CCP. They also, in their unfair labor practice proceedings, had the opportunity to raise those there and have that reviewed by the commission. So they've had all of the relief that they're entitled to.
Anything else?
If there are any other questions, I'd be happy to.
You know, Counsel, I guess if you could just expand on this a little bit. I mean, the CSC was created with, you know, very specific authority. It's unique to the state of Michigan. It has a specific kind of goal and objective that it was created in terms of its historical significance. And I guess, you know, I just, basically, how would you convince me that, you know, you're talking about terms and conditions of employment, you're talking about, you know, the various specific things. I mean, if you could just spend a little bit of time, how would you convince me that the CSC is not responsible for exclusive control over these issues?
So I think the Constitution recognizes how important the Civil Service Commission is, and our argument is trying to give effect to that. Our argument is pointing out that the Civil Service Commission is important, that it has authority, and that within its realm about what its rules provide and what decisions it gets to make, then it's the final authority. So I agree with that premise, that it's a very important agency. The Constitution says it gets to fix rates of compensation, and courts don't. The Constitution lays out how rates of compensation are to be determined. So I think that highlights and emphasizes the authority of the Commission and doesn't reduce it. And I think its ability to do rules emphasizes the same point. If there are no further questions, I'll reserve the rest of my time for rebuttal.
Good morning, Your Honors. May it please the Court, my name is Brandon Zook on behalf of the Appellee Michigan Association of Governmental Employees. What the state employer did in this case was make a bet that it could flout its obligation under that consensus agreement and get away with it. And its arguments and these proceedings will determine whether it turns out to be a bet that the state employer is winning. The issues, I believe, all revolve around whether there's an available remedy, whether it's too speculative, or whether, as the employer argues, it's moot, or whether, as the employer argues, it's something that is within the exclusive jurisdiction of the Civil Service Commission. And I think there are answers to all those admittedly difficult questions. Before I address that, though, I want to address something that's appeared repeatedly in the briefing by the appellant, as well as an oral argument today, and that is the argument that MAGE simply does not have a right to contract because it's not covered by the portion of the civil service rules which govern collective bargaining, because it has more limited rights than that. And as we've pointed out in our brief, this sort of agreement is specifically recognized in the civil service regulations. That regulation says, and it's Regulation 6.06 Standard 4D2, that the Coordinated Compensation Panel shall also consider any recommendations that represent an agreement or consensus between the Office of the State Employer and limited recognition organizations, that's MAGE, or between OSE and other participants in the coordinated compensation process. So this agreement, which called for 0%, then 1%, and then in the final year, 3% pay raise, and also called for MAGE to agree to health insurance concessions in return for at least that last year, which was the only real pay raise, is something that MAGE is specifically and clearly authorized to have under the civil service rules, and it should be recognized as such. Let me turn to the issue was framed by the court in its order for supplemental briefing and oral argument, and that is there a remedy available to MAGE given that the Civil Service Commission has exclusive authority over compensation? And we don't disagree that that is exclusive authority on the part of the Commission's part. But keep in mind that in last year's decision in Coalition of State Employee Unions, the court held that that authority is limited to setting salaries and wages, and that there's more than that involved in this consensus agreement. And this also gets into how outrageous the state employer's conduct in this case was. It got concessions by MAGE for the first 2 years of the contract. Those concessions were 0%.
Can I just ask a simple question?
Yes.
Are you conceding that the damages for MAGE cannot include a 3% increase?
I'm not conceding that. I recognize that as...
If you're not conceding that point, I guess I would ask you to explain, in a system where there is a decision maker that is exclusively empowered to determine whether an increase of any magnitude is made, the Civil Service Commission, how any court can circumvent that process. And isn't a 3% damage recovery just that, a circumvention of the authority of the commission?
Well, if damages are pegged at the 3% that was the issue.
If they include 3% increase.
If they are up to the 3% increase, I would concede that that is something that's equivalent to granting the pay raise, and the court does not have the authority to do that.
But that's why I asked the initial question. Do you concede that if there are damages that came from the state employer's refusal to abide by the agreement in this multi-year memorandum, that they cannot include what the Civil Service Commission refused to do, which is the 3%?
Damages, I believe, can include a portion of that. And as we briefed in our supplemental brief...
I mean, that's very important. I don't understand if this is an entity, the Civil Service Commission, which is the only entity subject to the veto of the legislature that can increase compensation, how any court has jurisdiction to order what they refuse to do.
Let me try to answer the question this way. The state employer in MAGE agreed to try to do something that ultimately is out of their power, and I concede is out of the court's power. It is exclusively within the Civil Service Commission.
Without our power, how do we, even if we go with you, it's a breach, and there's causation, how does a court have authority to award 3% increase that the Civil Service Commission didn't?
Yeah, I think the court can do it this way, and I probably would concede it wouldn't involve the entire 3%, but it would involve some portion of that.
How any? That's my question is, no one else has the authority to do what the commission does, which is to increase compensation. They chose to do 0 in this particular year. How can we award damages for something the commission refused to do?
Because I think what the court could appropriately do without impinging on that authority of the commission is look at the likelihood that the commission would have made that award if the state employer would have complied with its obligation under that consensus agreement. And that gets into the case law that we briefed in the supplemental brief.
Isn't that something that only the commission can determine? I mean, you're asking us to speculate something that could be put directly to the commission, I presume, and I'm very hard pressed to understand how we or any other court in this state can answer a question that is exclusively within the jurisdiction of another entity like that.
Well, that's
It's
necessarily.
almost a separate constitutional entity.
It's necessarily somewhat speculative because it was never presented to the commission as the parties contractually agreed to present it to the commission.
Yes, but there was a presentation to the commission,
Correct?
in which I'm sure Mage argued the state employer is violating our agreement by failing to support this 3%. Isn't
Right.
that in fact what would happen?
That is what happened, and that's not what should have had to happen.
I
What
understand,
should-
but the argument was before the commission.
It was, but the commission was in a position analogous to a court that should have been presented with a stipulation or a settlement, and instead was presented with a contested case. When a stipulation or settlement is presented to a court, chances are extremely high the court is going to go with what the parties have stipulated to.
Can I ask you, are you contemplating, is it somewhere in the recesses of your thinking that there may be an alternative pot, say one accessible to the state employer, from which an equivalent amount of money could be identified and obtained for your membership?
There is, and I'm not sure it would be an equivalent amount of money, but
But I'm saying, is that the means by which you seek to avoid the constitutional confrontation that would be involved if the courts were to stand in making this decision for the Civil Service Commission?
yes, and for instance,
Explain
that would
that.
be the value of the health insurance benefits that Mage gave up in the early years of the contract as the quid pro quo that it never got at the end for the 3% that was denied.
So in addition to the relief that you've already received, and in addition to relief that would really be defined essentially on the basis of a certain wage rate that's never been adopted by the CSC,
Correct.
you see yourself having the opportunity to argue for alternative forms of relief that have not yet been argued for.
That is correct. And please keep in mind that this is an interlocutory appeal, and those arguments have never been made below, and there's been no record of those issues made below because the Court of Claims bifurcated the issue of damages from its consideration of summary judgment on the merits. In fact, we filed a motion with the Supreme Court that I think of as sort of analogous to an offer of proof that if we were permitted to go back in front of the Court of Claims, we would talk about, getting back to the Chief Justice's questions, the fact that historically we believe the Commission has never failed to grant a pay raise if it was presented to the parties as a consensus agreement. But even if the court believes that just can't be done, consistent with the Commission's exclusive authority over the pay-setting process, what we could still get into is the fact that Mage gave significant concessions, and a dollar amount can be placed on those concessions with regard to health insurance benefits at the beginning of that contract, and those concessions have carried throughout. These employees wound up as the only employees who both got.
Counsel, I sympathize with, the situation. I mean, this is a very difficult circumstance and a very difficult situation. But I guess, where I guess I need to be a little bit more persuaded is I'm going to ask the same question to you that I asked to your brother counsel, which is, again, when you look at why the CSC was created, how the CSC was created, the manner in which it was created, and its historical significance, wouldn't your argument, for all intents purposes, ultimately have, if we were to go with this argument, couldn't this have a really profound impact on the power and the authority of the CSC for all other future matters? And in addition to the impact it could have on the CSC, I guess where I think I'm having some questions and concerns is with where the chief was asking, and I never really got a fullest answer, which is, at the end of the day, isn't this matter something which is really an issue between MAGE and the CSC and not MAGE and the Supreme Court?
I don't think that's the case. We understand the importance and the exclusivity of the Commission's powers under Article 11, Section 5. But at the same time, there is a separate body of law, one belonging with the Commission and one belonging with the courts. When you look at whether there's a violation of civil service rules, on the one hand, that belongs in the Commission. Pay setting process belongs with the Commission, and whether we can carve that out as part of the breach of contract damages, I think we can, but if the court disagrees, we still have the breach of contract damages arising from the other concessions that MAGE made. In a different setting, under the Public Employment Relations Act, it's very common for unfair labor practices within the exclusive jurisdiction of the Michigan Employment Relations Commission, and breach of contract issues within the authority typically of a contract arbitrator, but if there is no arbitration clause, then under the authority of a court to proceed on parallel tracks. There's concurrent jurisdiction there, not exclusive jurisdiction and not primary jurisdiction, because even though they arise from separate bodies of fact, two different bodies of law are being addressed here. And that's what I think we have here, Your Honor, is that we had our unfair labor practice proceeding in front of the Civil Service Commission hearing officer. We won, but in our view, we didn't get a meaningful remedy. And parallel to that, under a separate body of law, we have a simple breach of contract, a breach of the state employer's obligation to recommend that pay raise to the coordinated compensation panel, and it didn't do that. And there's no argument that it breached that contract, and it knew it was breaching that contract at the time it did it. It flouted that contract and bet that it was going to be able to get away with doing so. There is a remedy for a breach of contract, and that remedy can be defined, as I've indicated in my exchange with the Chief Justice, by taking into account the likelihood of the pay raise. But if the court believes that just can't be done without impinging on the Commission's authority, we can still look at the value of the non-salary and wage concessions that MAGE gave up to get what turned out to be the, Lucy hiding the football just as you try to kick it, the 3% pay raise. Those concessions are the value of the health insurance concessions that it made. There's a dollar amount that could be placed on that, and that's appropriately awardable as damages. When the state employer argues that relief is moot at this point because, after all, the coordinated compensation panel made the recommendation we wanted to the Commission, it said we don't care what the state employer is saying, we still think the 3% was awardable. The elephant in the room at that time, as the Commission noted in its amicus brief, was that everybody knew the state employer was now opposed to the 3% in violation of its obligation.
Thank you.
Thank you, Your Honors.
Do you care to address why the other damages, not the 3%, but the other damages, the alleged quid pro quo and the fringe benefits, are not damages that are cognizable in the judiciary as opposed to the Civil Service Commission world?
I think the starting point for that is that for them to be cognizable under the breach of contract claim, you would need a binding contract, and we've had the opportunity to identify the best authority for what would say that these are binding agreements, and the best my friend has pointed to is a statement of regulation that just says the Commission can consider agreements.
I mean, are you quibbling with the very notion that the state employer and MAGE sit down and reach agreements?
I'm saying they can reach agreements. I'm saying they're not identified as being binding agreements under the Civil Service Commission rules.
Well,
so that means, and I guess the simpler place to start to answer this question is to say all of these arguments were put to the Civil Service Commission, who understands its rules and understands what can happen.
That's what I was asking of opposing counsel. Wasn't this entire mess the fact that Mage was saying, we had a deal, they're breaking the deal, they should have argued to the CCP group that in turn makes the actual recommendation, that this was a joint proposal. And the commission heard all of that and still decided on no increase.
Precisely. So the Civil Service Commission heard these arguments, could have changed the rate, could have maybe changed the rate a lesser amount to account for the types of injuries they're talking about now. It could have said, okay, there was a fringe benefit. We think that entitles them to a 0.5% increase. They could have awarded relief that way if they'd wanted to. So all of that was within the authority of the commission, and they didn't do it. And so this court doesn't have a role, and the Court of Claims certainly doesn't have a role.
Anything else?
No. Thank you, Your Honor.
Then the case is submitted and the call is concluded. Thank you very much.